Oh, I'm sorry.
It's nice to sit next to each other.
Absolutely.
For once.
Ladies and gentlemen, welcome back. We have a very exciting and interesting subject this afternoon, so I think we will have no trouble keeping you awake. Starting after the meal is always a bit difficult, but I think we also have very knowledgeable speakers. I think that will be no problem for you at all to follow us. I'm Frank Schmiedel. I work for the European Commission in Washington. For the delegation there, actually only since August last year, so I'm pretty new to the subject. And the organizers, they wondered a little bit what they could possibly do with me, since I've done very different things before, and I'm not really a subject in this area. So they said, Frank, you should be a moderator, and I was very relieved so that I wouldn't have to expose my patchy knowledge about data privacy to you in a speech, and I will leave the talking to our distinguished panel. So thanks a lot to Duke University and Leo and all those who have made this possible and organized this very interesting and fruitful event. Let me briefly introduce the panelists in the order that they will appear. I initially wanted to have ladies first, but we thought it might be perhaps better to start with an overview of the issue from the American and from the European perspective. So John Kropf from the Department of Homeland Security will start, followed by my colleague Thomas Zerdick from the European Commission in Brussels. Then we have Anne Klinefelter, who is from the University of Northern Carolina. Then we have Francesca Bin Yami, whom you all know from here, from Duke, from the law school. And finally, Florence Audubert from INTERPOL. I think I will let the speakers introduce themselves a little bit more as they wish. I respect their privacy, so you're not obliged to tell more. That makes it even easier for me. I would ask you to try to stick to 10 minutes maximum so that we have enough time for questions afterwards. So, John, you're first. The floor is yours.
Thank you very much, Frank. And I was happy to do ladies first, but Frank did insist that I go first, and this is the modern age. I also would like to thank Duke University for hosting this, as well as a kind introduction from Frank. And it's also, I have to say, it's quite remarkable. I was impressed by the presentation this morning from some of the real luminaries in the privacy field, such as Professor Rodota and the European Data Protection Supervisor, Mr. Hustix, who traveled a long way to be here. So I think this is an impressive gathering of some very high-level privacy authorities. So I'm just happy to be up here sharing the microphone with some of them. And I don't think it should go by without noting that today, the 28th of January, commemorates the Council of Europe Convention on the Protection of Individuals with regard to data and data privacy. And I think it's clearly a sign that if we're celebrating what started to be a European event here at Duke University, we've arrived in a globalized world. My hope here is that next year, and I'm open to some invitations, that maybe we could celebrate a U.S. Constitution Day or the Freedom of Information Act Day at a very idyllic European university. And again, see me afterwards. I'm open to invitations. So our panel topic is pretty daunting. It's privacy and national security, transatlantic cooperation on counterterrorism, and whether the differences in our privacy systems are an obstacle to such cooperation. Well, I was going to try to do three things here in my segment, which is identify common principles on both sides of the Atlantic, then look at U.S. privacy framework and implementation, and finally some prospects for transatlantic cooperation and privacy. And I think I was going to do this in all of 10 minutes, so you probably think, that's pretty impressive. Well, I'm going to shorten that very first one on the common principles and simply associate myself with the wonderful panel that went this morning. I think starting with Commissioner Beals, he did a wonderful job of sort of setting the scene for you on the growth of U.S. privacy, and the rest of that panel really set out what were the common principles. So I think I can very, very quickly move off of that point and simply say that the U.S. and Europe share many of the fair information practice principles, or FIPS as they've come to be known, that were first articulated in 1973, and then were later adopted as part of the U.S. Privacy Act of '74, the 1980 OECD cross-border privacy guidelines, and of course the EU's 95 directive. And looking beyond just the U.S. and Europe, those principles have also migrated into the Asia-Pacific Economic Cooperation Body with their 2004 privacy framework. So they have really begun to spread themselves around the world. I think in terms of differences, very briefly I'll say that differences on a transatlantic basis seem to arise really over the implementation of those principles, cultural and historic differences, and even semantics. In fact, I wonder if the organizers of this conference sort of tipped their hat to that semantic struggle that we have, and to call this, use a hybrid term, data privacy instead of data protection or just privacy, I think is a recognition of that. So this really moves me into the U.S. privacy framework and the implementation of that. Some basic, real sort of basic highlights of the U.S. system is it is starting with a government structure based on a constitutional system where you have the three branches of government, and all of those branches have an actor who have different actors that play in the space of privacy, and they really create the checks and balances that go to working in the privacy sphere. And I thought I would just bring along, just as a prop, a copy of the Constitution, the U.S. Constitution, which is now in its pocket form, which is a very convenient thing to carry, but not to be outdone in brevity and size. I've got the fundamental rights of the European Union in even smaller size, so I wanted to give kind of equal time to recognize the authorities on both sides of the Atlantic. So with that, let me refer you to, in terms of the structure of U.S. privacy framework, there's a paper in your handout which is, I wrote last year, basically describing the oversight of U.S. privacy as a networked and layered approach to privacy, where you have many, many actors who all have a piece of the privacy sphere. And I'm talking in the government sphere now. In the executive, you have chief privacy officers, you have the Office of Management and Budget, you have the archives, you have Office of Inspectors General, you have the Department of Justice, who may prosecute privacy violations, and in Congress you have the Government Accountability Office, and you have congressional committees, and then of course in the third branch you have the courts. So all of them have a stake and a role to play in this area. But let me now go really into the three pillars of U.S. privacy framework, and they can really be summed up in a three-word theme, which is transparency, transparency, transparency. I think Commissioner Beals did a very good job in starting with the first pillar this morning, which is he talked about the Privacy Act itself. And I'll just rattle off the three primary statutes: the Privacy Act of '74, the E-Government Act, and also the Freedom of Information Act, which is oftentimes overlooked as being part of the privacy structure. But to start with, the Privacy Act and the E-Government Act are what I would call at the front end of the U.S. privacy framework. That is, they are there as authorities to ensure that the U.S. government is telling the world what is it doing with the information, how is it collecting it, for what purpose, how long it is to be kept, and how it is to be safeguarded. It's to follow the fair information practice principles. And again, hearkening back to Commissioner Beal's presentation this morning, he talked about SORNs, the systems of records notices, which are the building block that, that agencies must write one of these SORNs, they must publish it, they must give notice to the public. They do that through the Federal Register, and DHS also does it on its website. So in terms of numbers of SORNs, if you're interested in those kind of metrics, since the Department of Homeland Security was created, we have done approximately, we've reviewed, revised, and published approximately 60 systems of records notices, and you can find those on DHS Privacy website. And I'm not going to spend really much more time on that part of the three pillars. I really wanted to move to the second part, which was the E-Government Act. And that is really about trying to create as much transparency as possible through the requirement of privacy impact assessments, or PIAs, as you may have heard them called. PIAs, again, it was really an attempt by Congress to make sure that agencies articulate in as forthright a manner as possible, again, what agencies are doing with personal data, how it is collected, what are the systems for collecting it, what's to be done with it, and how long it'll be kept for. And DHS has been a leader in this area. As a matter of fact, we have done several department guides that have been issued and adopted by other government agencies that do PIAs. Our Director of Compliance, who is a very stern taskmaster to all the rest of the DHS components, of which make up about 200,000 people, applies what she calls the grandmother test, PIAs, which is your grandmother should be able to read and comprehend what is in a PIA so that it is understood and known to the average grandmother on the street, if you will. And we've done, again, if you're counting numbers and you like that sort of thing, we've published approximately 120 PIAs since the department has come into being. And this is really an essential part of transparency, and we can't emphasize this enough, that if you want to know what DHS is doing with a system, you can go to our website, you can see those PIAs published. And we have really pushed this policy over and above what the law requires, and in fact, we have required that even national security systems that are classified and are very sensitive, we have internally pushed and had a policy adopted that those systems too must abide by PIAs. They have to write PIAs, which has been an internal victory for us, and we continue to try to push policies internally within DHS to make sure that these systems are disciplined in terms of how they use personal identifiable information. I know my 10 minutes is ticking by quite quickly, and I'm having to cut down some of my material here, but I'd like to really look at the back end now of privacy, which is the FOIA part of it. The FOIA, for many of you who are probably already familiar with it, Freedom of Information Act, it basically is the way to ask the government, are you doing what you in fact you promised you would do with our personal information when you publish these SORNs, when you publish these PIAs? It's the way of granting access for anybody, regardless of whether they're U.S. citizen or not, can seek access from the government and ask for their personal information. And you may think FOIA is old news. It's been around since 1966, but Congress just actually, they updated the law recently with some changes to it. So they do pay close attention to this. It's an essential part of transparency. Just to give you another example, to go to some numbers from October of '05 to September of '06, the Department of Homeland Security processed 112,000 Freedom of Information Act requests, and that costs about $28 million to process. I think when the FOIA was first passed, then Professor Scalia had called it the Taj Mahal of unintended consequences. He said, you know, this is going to take on a bigger life than people realize, and there were estimates at the time that it wouldn't cost the government more than about $1 million to implement. And it's really a robust form of enforcing transparency. And the last thing I'll do is very briefly touch on a word about DHS itself. When DHS was created, Congress in its wisdom decided that there needed to be a statutorily mandated privacy officer in that department. This was the first time that this actually was put into law, so that the DHS Chief Privacy Officer has by statute authorities that he or she can use to bring all of these privacy policies to bear, and that, you know, that includes the use of the SORNs, as I mentioned, the use of the PIAs, and also issuing policy statements. We've issued a couple of policy statements that I think are pretty important in the area of PII. One is a policy on what we call mixed systems. That is, if you have a system of records that has both U.S. and non-U.S. Personal information in it, that the Privacy Act should really apply as a political matter to the entire system. That is, in other words, you may know that the Privacy Act is limited only to the application of U.S. citizens and lawful permanent residents. Well, this was a step to push the policy mechanism as far as possible within our authority to make sure that, at least as a policy matter, people who were not covered could have things like access and redress as an administrative right. The access, of course, is already guaranteed through FOIA. We've also tried to maintain a very public face to make sure that there is input from the privacy advocacy community. We've held public workshops on the use of commercial data, we just had one on CCTV in December, and we had very good participation from our overseas friends. And last, we have an advisory committee, which is an essential function in allowing those experts from the commercial world and the academic world to provide advice and guidance to the privacy policies of DHS. So there really is a lot to cover here, and I hope I'll have more of an opportunity at the Q&A to go into it. And I just have a word on future prospects. I am an optimist, and I really do believe that there is a lot of room to be optimistic about cooperation transatlantic cooperation between the U.S. and our European friends. And we've heard a lot about the differences. I do think that there are ways to bridge those differences. They have not always been easy, but there are examples of international information sharing agreements out there in the law enforcement and justice and home affairs area. As I say, they've not always been easy, but we have things like mutual legal assistance treaties, and of course we have the PNR Agreement, the SWIFT Agreement, and the DHS office has been involved, the Privacy Office has been involved in reviewing and participating in those discussions to ensure that privacy is addressed. And it doesn't always make us the most popular office in the department, as you can imagine, but it is recognized and supported by the Secretary of Homeland Security that we participate. So we do our job to ensure that privacy is fully addressed. So in closing, before I hand off to my colleague Thomas, I mean, the U.S. and the EU are going to face this challenge together, and if we can't come together as two of the biggest liberal democratic structures that are on the globe, I would think that we would be in a lot of trouble. But I really feel approach based on fair information practice principles, existing information sharing agreements that are out there, and mutual recognition of some type may be leading us to the path where we could work out some common approach. So thank you for your time, and I will turn things over to Thomas.
Okay.
Thank you, John. Over to you, Thomas.
Okay, thanks. Yeah, ladies and gentlemen, I'm also honored to be here with you and speak about privacy and data protection from a European Commission point of view on today's Data Protection Day or Privacy Day. Also, thanks to the organizers for this event, to having invited me, having me here, and I'll comment on privacy, security, namely how it works in Europe and what it actually then means for transatlantic cooperation. Let me start with some numbers. We in the European Commission, we have commissioned a survey for citizens, and we were asking, how much do you trust people, institutions, public authorities when they handle, process your personal information? And the results were out today. So one of the results is that citizens in the streets, they were telling us, we trust, roughly 50% of the citizens said we are trusting the police that they are handling our personal information in a correct way. 50% is a good number, but I don't know if it should rather read 100%. So there is a trust thing when we talk about privacy and security. A quick turn to privacy, public security, fighting terrorism. Terrorism is an awful reality. We all hate it. We have all reasons to hate terrorism. And there is no difference when we are in Germany or Greece or Spain or in the United States. So we need to provide our citizens with some security. That's beneficial for citizens, that's beneficial for our economy, that's beneficial for the society at large. So inevitably, to address security threats, public authorities will have to process personal information. They will have to have some information about individuals. But, of course, that must be with certain limitations. And public security can only be provided in the name of the law and upholding the rule of law. Upholding the rule of law means essentially protecting human and fundamental rights, and in particular against undue interference of public authorities when using personal information about individuals. That's the line of thinking which we in continental European legal thinking we call Rechtsstaat, which is borrowed from the German jurisprudence on this. So some people say, if you want public security, if you want to preserve our freedoms, you have to sacrifice these fundamental rights and you have to sacrifice privacy. So if you invoke these fundamental rights, then you won't be able to fight terrorists. Well, that is clearly wrong. This is exactly what the terrorists want to achieve, but we are not going to get them led away with that. So I would argue that the fight against terrorism, providing public security, protecting fundamental rights, they support each other. And respect of fundamental rights, and particularly privacy, is a condition for an effective fight against crime. Because only if you respect fundamental rights, you will be sure that the criminal justice system works. You will be sure that you can use evidence in court. You will get criminals convicted. And you will have sentences which are not going to be annulled because of non-respect for fundamental rights. And ultimately, only if you respect those guarantees, then your partners in the global fight will trust you and be willing to cooperate with you. Again, the trust issue coming up. Let me turn to, again, privacy as a fundamental right in the European Union. We've heard about this before in the morning, but I think it's illustrative and instructive to display where we're coming from. What is the way of thinking behind this? And you know that the protection of fundamental rights, and in particular the right to personal data protection, is deeply rooted in European culture, not least because of our historical experiences with abuse of personal information. Anybody who's been watching the recent movie, the German movie, The Life of Others, will recall that's a very good demonstration of why we need personal data protection. And then again, let me quote our highest court in the European Union, the European Court of Justice. Quote, "Measures which are incompatible with the observance of human rights are not acceptable in the European community." Unquote. So, we have an institutional framework. You've heard about the European Convention of Human Rights. You've heard about the traditions in member states. Those are principles which are general principles of the Union's law. You've heard about the Charter of Fundamental Rights, which is our Bill of Rights now in Europe. Professor Rodota was referring to it and writing it actually in some parts. We've heard the reference to Article 8 in the Charter of Fundamental Rights. I think it's worth reading it because it really gives the essence of what I'm talking about. What is the fundamental right to data protection? So Article 8, paragraph 1 reads, "Everyone has the right to the protection of personal data concerning him or her." Very simple. Paragraph 2, "Such data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law." Second sentence, "Everyone has the right of access to data which has been collected concerning him or her and the right to have it rectified." Paragraph 3, "Compliance with these rules shall be subject to control by an independent authority." That sounds nice. Now, what does it really mean? So, this is a set of values which I will have to apply in my daily work. So, I need to understand what we're talking about. Again, first paragraph really says there is a fundamental right to data protection for every individual. As a consequence, EU privacy laws have to give effect to this fundamental right, and they have to apply to all individuals, regardless of citizenship and place of residence. And because it is a fundamental right, it applies to all levels. It applies to the European Union level, at the member state level, regional levels, local levels, everything, every level. This fundamental right extends to all public authorities. It extends to private entities. Regardless of what they're doing, they need to respect this. So basically, there is no no-go area when it comes to the protection of personal data. Again, the second paragraph of Article 8 gives you your rights as an individual. We've heard this before. You can question anybody who's collecting and using your data. You can question anybody, be it a public authority or a private entity. You can ask for a correction or deletion. And of course, the last paragraph says there is an independent authority which supervises what is being done with this personal information. And they do so also in the law enforcement sector. So there is a full set of protection. Again, you have a fundamental right. This one can be limited under certain circumstances and under certain conditions. Again, me as a lawyer in my daily work, I can check it out. I can see which conditions have to be met in order to limit the fundamental right to privacy. And we start essentially from the thought that any government access to personal information, to personal data, is per se an interference in that right. And this is okay. Any limit, but I read Article 52 again on the Charter, and it gives me indications what I need to look at. It says any limitations on the exercise of the rights and freedoms recognized by this Charter must be provided for by law, first thing, and respect the essence of those rights and freedoms. Subject to the principle of proportionality, limitations may be made only if they are necessary and genuinely meet objectives of general interest recognized by the Union or the need to protect the rights and freedoms of others. So basically what this is saying is any government interference, every specific public authority action on my personal data needs to be fully justified. Purposes need to be specified beforehand. I don't have to show that I'm going to be harmed or something. The burden of proof is on the government, on the public authority. Because if these rights are then violated, everybody can complain to the Data Protection Supervisory Authority or ultimately to an independent tribunal for judicial review and to seek justice. Again, this is the set of rules which I have to comply with in my daily work in the European Commission. This is how the European Union is supposed to work. And as you may also know, whenever we try to propose legislation, we will involve, for example, and seek the opinion of the European Data Protection Supervisor. And he will then also go to the Charter and read these and check what we propose against the principles I've just mentioned. Briefly, what does it mean for privacy protection in our transatlantic cooperation? Coming to the title, conflict will lead to nothing. There can only be cooperation and dialogue between Europe and the US. I'm convinced of that. John mentioned it already. We have some certain commonalities. We have certain rules. We share the same ideas for the privacy protection. And we have differences. And John has mentioned them already. Again, for example, the US Privacy Act only applies to US citizens and legal residents, whereas EU privacy laws, as you've heard before, because they give effect to a fundamental right, they apply to all individuals, regardless of citizenship or residence. And yes, we've shown in the past that we can work together. And we should. But again, it comes to the sense of trust. I come back to the numbers I've just mentioned. 50% of European citizens believe that European police is handling their personal data in a correct way. No. How much will they trust law enforcement agencies outside the European Union? So basically, whenever we work together, Europe and the US, we need to be able to show to our citizens that they can trust these authorities. They need to know who gets information, why public authorities in another state, in another country, need that particular set of information, for what purposes, what are the protection mechanisms, and how can it be enforced. So we must meet these expectations. I'm sure we will, but it's also a legal obligation upon what I'm doing. To conclude very briefly, so we need data protection if we want to fight crime and terrorism effectively. That shouldn't be a barrier. Privacy should never be a barrier to fighting crime. It should be a yardstick of the efficient fight against terrorism. It should be a condition for our success. The lack of efficient protection of personal data is as much to be dreaded as the efficiently fighting crime and terrorism. So the use of personal information is just like eating juicy fast food. More is better doesn't work. It'll only lead to obesity. Less is more, really. yes, I'm convinced we need to work together. Our final goal has to be that we guarantee all individuals a high level of protection of personal data, and then on the free movement of that personal information across the Atlantic. But let's work on this together, because when it comes to trust, we need to say more is better. So thanks for listening, and I'll be happy to answer any questions later.
Thank you, Thomas. Now, after these overviews, I think we now go more into the specifics of the issue, starting with Anne Klinefelter. Anne, the floor is yours.
Thank you. Anne Klinefelter. I am speaking to you today as a librarian. I'm a member of the law faculty at the University of North Carolina, just down the road in Chapel Hill, but I'm also director of the law library. And librarians in this country have played a special role in this controversy, this debate about privacy and security. And I want to share with you some of the things that I've learned from our role here. Mainly, one of the things is that there's a special value in stories. And another thing I want to talk to you about a little bit is the difficulty and how I've experienced it in balancing privacy and other interests such as security. After the attacks on the World Trade Center, we had a very powerful story out there. It still moves me to think about it. But we had to come up with some other stories to articulate why we should care about anything other than security, particularly privacy. And librarians around the country got together very quickly and identified in a very long act that was passed very quickly provisions that might impact your privacy as we see it in libraries. And very quickly I found myself on the circuit to try to talk about this. It turns out that librarians provided a very important story. We were a metaphor. As we've been talking about throughout the day, the law of privacy is so complex, particularly in the United States. And if you're going to talk to people for 5 minutes of their time, you've got to have something very concise and something very connecting to bring to them. And that's what librarians did. They had this image people could connect with very easily about government surveillance that might be out of proportion to the security concern. And also, librarians turned out to be a very motivated, organized, and sympathetic advocacy group. So I found you need a story and you need the storytellers so that you can talk about consequences. We have terrific speakers here, writers, scholars whom I read who have great ideas about ways to address privacy concerns and security through amendments to legislation, through constitutional challenges. Those are all key. But I found through my talks around the country that the citizens don't really get it unless you give them other stories. So I'm going to tell you a little bit about my experience there. And you know, we do this in scholarly pieces. We always start out with an example. And I'm just saying we need to do that more. So my experience was all of a sudden I believe it was early in 2002, I was going to Fayetteville, where Fort Bragg is, to talk about on a panel. There was a public forum of 200 people who showed up, and I was terrified. I'm at an Army base. We're about to go to Afghanistan, and I have to defend privacy to this crowd. And it was amazing. I actually ended up with a standing ovation, and it wasn't me. It was just what I was talking about, people really connected with. And so I think that's important. Librarians were the first major voice identifying about how the relaxed standards of the USA Patriot Act really threatened to upset the balance that we were familiar with. Librarians already knew about state laws, 48 states plus Attorney General opinions in the remaining 2, protect the confidentiality of library records, of your reading habits. But like many other privacy laws, the exceptions threaten to outstrip the rule itself, especially if it became so easy to get access to these records through the relaxed standards established through the Patriot Act, through FISA court orders, or through national security letters, and many other provisions of the Patriot Act, too. So I found myself invited to speak, of course, to library administrator groups, to public forum, to newspapers, to radio programs, at law and library conferences, and I was approached by many people and organizations who are privacy advocates. And I'm not the only one. Librarians across the country were. So we were very much the subject of editorials, political cartoons, and eventually the frustration of U.S. Attorney General John Ashcroft, who went on tour to defend the Patriot Act and ended up exclaiming that librarians were delivering breathless reports and baseless hysteria about access to your reading habits. And you have to consider that the stereotype of the librarian, this was a formidable opponent in this battle of stories. Librarians, as I said, were organized. I don't know if you know this, but we don't all catalog a book. We copy one person's cataloging of a book. We are really organized. We have mailing lists. We get together at association meetings. We know each other. We help each other. And we're also very public-minded. Librarians consider the public library the key to an informed citizenry. And many of them are ready for civil disobedience. So it's a pretty amazing group. And also very experienced. From the 1970s, there was a movement, a program that the FBI put in place to monitor those who were using public libraries to obtain technological advantages that would then be taken back to the Soviet Union. So librarians were very aware of how they could be used. Many of them, some library staff were recruited to be part of this surveillance. And so it was at that time that that was when all of those state statutes were pushed through. So librarians had some experience in this. Also, in our graduate programs, there's an emphasis on privacy as a banner, our ethical commitment to the privacy of those reading habits and research habits of people who come into the libraries. So, in general, librarians were a fairly respected storytelling group. And we ended up collaborating with a lot of other groups who got together with communities and cities, even states, who passed resolutions objecting to many of the excesses of the provisions of the Patriot Act that threatened privacy. And you find in most of those resolutions that were tracked on the ACLU website that they had provisions talking specifically about library records. And all of you know that library records are only a small part of all the records available, healthcare, financial records, all sorts of things that we've been talking about. But because librarians were so much involved in this discussion, library records became prominent. Then several bills were introduced into Congress to amend the Patriot Act, and they started off with exceptions for libraries. And that's because of this advocacy. And in fact, there was a case in Connecticut where, because of the non-disclosure clauses that go along, that attach to national security letters or FISA court orders seeking access to information, there's a difficulty in finding a plaintiff. You know, you don't know if your information has been sought unnecessarily. There were difficulties in challenging, but it turned out in the midst of claims by the government that library records were not being sought, that in fact they had been in Connecticut. And the leak of that information about the identity of the plaintiff led to some effects in the renewal of the expiring Patriot Act provisions. And in fact, you'll find that national security letters don't always apply to libraries. So I think that what this told me is that the story is very important. It's important for us to think about, if you're a privacy advocate, what are the ways that we can address that legislatively or through constitutional attacks. But you also need to have some control over the stories. I can tell you when the radio comes, the radio interviewer comes, or the newspaper reporter comes, you need to have 2 sentences and you need to have a clear example. You need to say, would you be embarrassed to go to the library to explore homosexuality if you were exploring that and you thought that you were being observed? What if you have toe fungus? Do you want everyone to know? You think about little stories like this that are the kinds of things that public libraries might also serve. What if you're exploring Al-Qaeda? You want to know more about what's going on. Does that automatically put you on some kind of tracking list? So we talk, in effect, about chilling effects. But the difficulty really is that, as others have pointed out, library privacy in general is a wonderful value until you have a competing value. You have that other story. And so I think it's important for us to think of ways to educate the public about this. And that's an important part of the goal of this day and this conference, is to think of ways, because our culture is not based on a lot of primacy of privacy. People will be able to tell you that they value privacy, but their behavior indicates otherwise. And they're all for privacy until you show them the competing value, and then, oh, well, maybe not so much. I do want a discount. I do want security. And I have students in my privacy law seminar who are all about the social networking sites, MySpace, Facebook, the things they put up for the public to see, blogs. It's just mind-blowing to think that how are we possibly going to talk about what is in terms of the Fourth Amendment, what is a reasonable expectation of privacy when our environment is so, our habits and our framework is not supportive of that. So I think we have to borrow some more stories. Librarians are not a perfect metaphor. We only advocated for libraries, so that didn't take us very far for other areas. I like the idea of borrowing the European stories, and Professor Bignami starts one of her recent articles about the story of Nazi use of government data for conscription and, as of course, worse things. So we need to think of these stories about misuse of data, consequences, and bring those to the forefront in order to counter some of those images that are burned on at least the brains of United States voters. And I have some other stories to tell you if there's time about how we actually deal with privacy versus customized services in libraries, because although we're an advocate, we're also a data collector. So thank you for this opportunity to share this story with you.
Thank you, Anne. And before I hand over to Francesca, I just wondered how the librarians as a storytelling group compare to our modern librarians or internet librarians, but I think that is something that perhaps the next panel can deal with. I'm not sure if it's the same kind of stories that will be told, but certainly something interesting to compare notes. So now it's Professor Francesca Bin Yami from Duke University. Francesca, it's your turn.
Thanks very much. Well, I'm going to actually speak about a story, a specific transatlantic dispute, which I think illustrates some of the differences between our two privacy regimes in the national security area, which have been talked about in maybe a little bit more abstract terms earlier on the panel. And that's the story of the PNR dispute, the passenger name records dispute. So what I'd like to do, and I know most of you are the initiated, and so you know the ins and outs of this, but I would like to narrate it and then draw out what it is about these two different regimes that has led to this conflict as well as others, in the SWIFT case and perhaps others. And so this is a dispute between the United States and the European Union, and it originates with September 11th, 2001. Right afterwards, Congress passed a law requiring that airlines provide the U.S. government with information on passengers flying into the United States from abroad. And as a result, the U.S. Customs and Border Protection Agency began requiring that European carriers give them access to the data contained in their passenger name records. And one quick word on what a passenger name record is. It's not just basic information such as names and passport numbers. It's detailed information such as your credit card number, your choice of meal, your next of kin, your past travel history, your hotel reservation. So it's pretty comprehensive. And what did the U.S. government want to do with this information? Well, it wasn't just stopping suspected terrorists from boarding planes when they were about to fly into the United States, but it was also about surveilling people after they arrived in the United States. And now, what were the consequences for a European airline that decided not to comply? Well, it was basically the exercise of U.S. territorial jurisdiction, which is entirely legitimate. It was the denial of landing rights and a fine of $6,000 per passenger. Now, already in July 2002, less than a year after September 11th, the EU's European Commission notified U.S. authorities that this requirement might indeed be in violation of European data protection law. And after 2 years of going back and forth and wrangling about this, in May 2004, an agreement was adopted between the EU and the United States. And in the PNR agreement, the U.S. government gave the Europeans certain privacy guarantees, promising to limit its use of European PNR data. And in return, the Europeans declared that the U.S. PNR scheme was adequate. It gave the blessing of adequacy, meaning that European airlines could transfer their passenger data to the U.S. government without fear of being prosecuted by European authorities for having violated their passenger privacy, for having given over their passengers' data to a privacy inadequate third country. Because under European privacy law, when you transfer data abroad to a third country, that third country has to be considered adequate, or there have to be certain kind of special guarantees surrounding the data transfer that would be the equivalent of an adequacy finding. And Europeans, and many of those sitting in the room here, don't say it's identical, and it's certainly not identical, but it's a rough meeting of European data protection standards, the consideration of adequacy and the finding of adequacy. So we have this great agreement, May 2004, but 2 years later, the European Court of Justice comes in and does its work and undoes the PNR agreement. It holds that the agreement was invalid, but it wasn't invalid on privacy grounds. It was invalid on internal European institutional grounds. According to the court, this agreement, it's very reasonable to me, was designed to promote law enforcement, national security work. But it was impermissibly based on the EU's powers to promote a single market. So the EU had impermissibly used its market powers in this law enforcement area. And because of that, the agreement was invalid on the European side. So the agreement had to be withdrawn. And the Americans and the Europeans were back to the drawing board. So it's a long saga. October 2006, they reached a temporary agreement which would give airlines coming into the United States from Europe some comfort. And in July 2007, another permanent agreement was put into place. It's very recent. And what are the terms of this new 2007 agreement? Well, it's pretty clear to most observers that the terms are less favorable to the Europeans this time around, more favorable to the Americans. And here I'm going to briefly recap what's been said throughout the day about what are the basics of data protection and data privacy. In my view, it's useful to think of data privacy in sequential terms. The guarantees that surround the collection of information, the use of information, the retention of information, and then the right of access that individuals have to go in and check the information that's on them. And here, really the basic philosophy of data privacy, which you've been hearing about the entire day, is that the less information out there, the better. The less information, the lower the risk that there's going to be surveillance by the government, the lower the risk that personal data will be used for legitimate purposes, such as suppressing political protest. Less data, the lower risk that the information will be wrong or will be stolen by hackers. So that's the basic philosophy here. And onto the data protection criteria that I mentioned earlier, the collection and rights of access. Not much has changed between the two agreements, the 2004 agreement and the 2007 agreement. And I'm sure we might have a lively debate here because many of the people in the audience here have considered the agreement themselves, and so will have their own opinions. But in my view, not much has changed on collection and rights of access. Basically, the same amount of data on European passengers is being collected by the American authorities. And basically, the principal avenue of access is, as we've seen, the Freedom of Information Act, which is being used also for European citizens. The big changes really are on the use and the retention part of the agreement. The information, as before, can be used for preventing and combating terrorism, as well as other serious transnational crime. So that's consistent with the 2004 agreement. But unlike before, the language is a little bit less clear as to how it can be shared with other authorities other than the Bureau of Customs and Border Protection. Because the agreement says that information can be shared if it would support the examination of cases involving counterterrorism, transnational crime, or public security, and can be shared with other authorities in the United States, federal and local, whose mission it is to engage in law enforcement, counterterrorism, and public security protection. Now, in the 2004 PNR agreement, it was clear that this was only information transmission on a need-to-know basis, i.e., if there was another Mohammed Atta out there, you could get the information from CBP, Customs and Border Protection, on all the flights that Mohammed Atta had taken into the United States from Europe. Now it's not so clear. Now it might be possible, depending on how you interpret it, to transfer wholesale information from PNR records to other government agencies. And on the retention score, which is the last data protection criteria here, the 2007 agreement is also less favorable to the European side. Here, the PNR data now can be retained by the American authorities for a total of 15 years. And before, it was a total of eight years. So 15 years now, 8 years before. That's the tale of the PNR dispute in very, very brief, cursory terms, because it's a long saga. It's useful to recapitulate it because it narrates and it illustrates very nicely the way in which the differences between these two systems can lead to a certain amount of conflict. But why is it that the Europeans insist that the American data protection scheme is inadequate? Because as we've heard today from John here, and in his many writings, there is a lot that's similar to the European scheme. There's general legislation like the Privacy Act of 1974. There's specific legislation like and specific legislation regulating access to information by spy and police agencies, and information such as telecommunications data and financial records. And there are also a lot of internally binding guidelines out there issued by the Attorney General that structure how law enforcement and national security investigations occur. And they limit how information is used, collected, and so forth in those investigations. And this very comprehensive set of rules, the general ones, the Privacy Act, the specific ones like the Stored Telecom Act, as well as the internal rules, they really proceed according to the same philosophy as the European rules, meaning the less information out there, the better. We want to, first off, make information collection transparent, and then we want to limit information collection and limit what's done with the information after we get it. So really the philosophy behind these rules in the United States is very, very similar. So why is it that the Europeans keep on claiming that the American scheme is inadequate? And here there are many parts to this, and I'm going to go, we've been through many of these already. What I'd like to do is just review them from the most fixable, assuming that you want to fix the American system, and that's an assumption for purposes of this very quick exposition here, to least fixable. Now, first, there are a number of exceptions to the Privacy Act, particularly in the National Security Agency, in the national security case, excuse me. And so, as a result, some of these requirements don't have to be complied with by spy and police agencies, when they're acting in a law enforcement guise. And so on this, I think we might have some discussion here, but my sense is that many of the Privacy Act notices that we see in the security area don't maybe go to the heart of the matter. Maybe they're more on the personnel side of things. And this is something where I think it would be very beneficial to have some debate. So that's the first difference here, and the first reason why Europeans might think that the American system is inadequate. Second, my sense in looking at the sector-specific, data-specific legislation on the American side is that in regulating the police and the national security side of the FBI, the regulation tends to be very front-ended, very focused on collection, but not so focused on what happens afterwards. What happens to the information after it gets into the hands of the FBI agent who's conducting the national security investigation. And my sense is there aren't significant restrictions on the use of the information, and mainly in the transfer of the information to other government agencies that might potentially have a use for it. And indeed, the whole impetus of the reform of our legal scheme since 9/11 has been to facilitate sharing of information. And so this is precisely the opposite of the state of affairs in many European countries. For instance, in Germany, the Foreign Intelligence Service, which can gather a huge amount of information on individuals, is quite extraordinary. They can monitor telephone conversations without much of a suspicion of anything. But they can't transfer that information to the federal police unless there's a reasonable suspicion that an individual is engaging in one of a series of statutorily listed acts, crimes that are considered to be serious. So there's a real restriction on the sharing there. And that's one of the big ways in which a system like the German system tries to guarantee privacy. So sharing, I think, is one difference between the second big difference between the two systems. Now, the third difference that we've heard about earlier is the lack of an institutional counterpart in the United States to a European independent data protection authority who would enforce privacy law. So there's no one like Peter Hustings. And I know that we have chief privacy officers here in the United States, and they do incredibly valuable work, and I know that we have at least one former privacy officer in the audience here. But no American constitutional lawyer would call these individuals independent officials. The definition in American constitutional law of an independent agency is somebody like Mr. Beals, somebody who is appointed for a fixed term. And the chief is not removable at will by the secretary or the president. And that's not the case of the chief privacy officers who exist today in the various departments. And so in terms of their connection to the government, they're more dependent, less independent than European authorities. And also their powers really aren't the equivalent of European data protection authority powers. Now the last big difference, and this again we've heard a lot, but I think it's important to reaffirm it here because it has real practical consequences, is that in Europe, data protection, initially it was privacy, and now it's going to become data protection with the charter, is a fundamental right. In the United States, it's not. And it's not only rhetoric. the difference in considering something a fundamental right as opposed to a matter for legislative congressional action is that when there isn't a legislative act that captures something that we think is bad, right? There's no other recourse in the United States. You can't bring a constitutional court case. If technologies change, if the situation and the data change, you can't do anything about it if the legislation doesn't cover it. Whereas in Europe, where it's a fundamental right, you can go to court. And you can go to the German Constitutional Court and complain that your basic right to informational self-determination has been violated. And this, of course, serves a function in disciplining also the way in which governments structure their spy and police and other kinds of programs. So this is, I think, a very significant difference, and one that explains a lot of why it is that we've seen a number of conflicts between the US and the EU over time. Now, I've gone through my list of differences, and you can understand why I said I was ranking them from most fixable to least fixable, because plugging up holes in the Privacy Act or attaching certain restrictions to personal information sharing, well, that's possible to do on a political level if there's the will to do it. It's harder to create an independent agency that would have ombudsman powers over all of the federal government because, first off, it would require building an institution from scratch. And secondly, there is a certain amount of constitutional law, and we were talking about this a little bit earlier in the day, that gives the president a monopoly on executive powers. So there might be some problem with giving an independent agency disciplinary powers over an executive branch office like DHS. That constitutionally would be a problem. And the last and the least fixable is this difference between privacy and data privacy as a fundamental right, whereas data privacy as something that Congress needs to fix if it needs to be fixed from day to day. And this is very, very hard to imagine any kind of current fix in the American system because it would require a new interpretation of our Fourth Amendment and or our 14th Amendment of the Constitution. And this kind of reinterpretation to a much more expansive definition of what is privacy, to include data privacy, is very hard to imagine given the current composition of the court. And so I hope that I have suggested both ways in which conflict might be pragmatically overcome in the future and less pragmatically reproduced over the future. Thanks very much.
Thank you, Francesca. I think we have taken good note of your suggestions, and I think we'll get some inspiration from them. And last but not least, we have now our last speaker, who is Florence Audubert from INTERPOL. Florence, now up to you.
Thank you. Good afternoon, ladies and gentlemen. I have been asked to contribute to this discussion about the required balance between fundamental human rights and international police cooperation by presenting Interpol's experience. Let me start by reminding that crime has become even more international since the mobility of information and of individuals has increased. Several forms of crimes, such as child pornography, cybercrimes, or terrorism, have become extraterritorial in nature. Hence, it has become essential for law enforcement authorities to work together. And based on Interpol's experience, I feel comfortable to say that in this new area of globalized crime, quick, secure, and efficient exchange of high-quality information on one hand, and proper observance of data protection principles on the other hand, are focused on the same goal, namely to guarantee the basic rights of individuals to live in peace. But in case of any doubt concerning human rights observance, the risk is that police cooperation may be denied, and the right of individuals to live in peace may be endangered. So I will try to illustrate how Interpol faces the two risks of attempts to national security and to fundamental rights, based on concrete examples. Before that, I think it's important to have in mind the context in which Interpol operates. One figure, 186. It's the number of Interpol's members, which of course do not have the same technological development, the same culture, and the same legal regime. In this context, Interpol's aims are to ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of the laws existing in the different countries and in the spirit of the Universal Declaration of Human Rights. To make it possible for each Interpol members to contribute to the international fight against criminality, compliance with its internal legal framework, Interpol's rules are based on the principle of national sovereignty. According to this principle, the source of an item of information remains its owner and retains control over it. So it can impose some restrictions on the access to the information. And in practice, countries use that possibility. For example, when they fear either that the information will not be properly handled or that the action taken based on the information provided would attempt to the fundamental human rights of individuals. Nonetheless, those national restrictions represent a real stumbling block for international police cooperation. And this obviously has adverse consequences on public safety and on the basic fundamental rights of individuals. One could envisage to prohibit the possibility to impose some restrictions, but in the context of global cooperation with so many different countries, the risk would be even more important, as the country's source of an item of information would probably prefer in that case to retain its information rather than to communicate it to everybody. To encourage full and prompt exchange of information on matters of common interest within the spirit of fundamental human rights, Interpol developed several tools. First of all, it set up a secured, modern, and global police communication system called I-24/7, to which all Interpol members are connected. It also manages several databases which are accessible to authorized entities through Interpol's network. And Interpol developed a unique global regulation dedicated to the processing of information. Some main principles qualify those rules. Neutrality. Interpol's constitution prevents the organization from entering into predominant political, military, religious, or racial activities. Transparency. Every country has the right to know what can be done with its information. Respect of fundamental rights. As mentioned before, Interpol's constitution expressly refers to it. Respect of data protection principles, which are similar to those established by the EU and by the UN guidelines concerning computerized personal data files. And finally, Interpol holds emergency support and operational activities to provide legal and technical assistance to its members. So the benefits expected of those tools are more confidence in the way the information may be handled, more important flow of data, improved quality of information processed, and less infringements to individuals' rights. Nevertheless, in practice, it happened that Interpol had to stop its cooperation with its members because at some stage of the police cooperation, a fundamental right of an individual has not been respected. So let me present you two cases that Interpol had faced and which illustrate how the violation of national law and international standards can be counterproductive. As you may know, Interpol can issue what we call notices, which are international bulletins generally issued at the request of one country for the search of a person in view of his arrest and extradition and subject to a national or an international arrest warrant. In a case, a red notice has been requested by a country against a political dissident for corruption. As Interpol can't enter into predominant political cases, it studied whether the political elements of the case were predominant. It concluded that it was not the case. Consequently, it issued the red notice, and the person concerned has been arrested based on this red notice. But afterwards, the person subject to the red notice asked for its cancellation. It argued that it was issued in violation of Interpol's rules, and to support his request, he provided new elements based on which Interpol finally considered that the case presented a predominant political character. Consequently, Interpol withdrew the red notice. In another case, a terrorist attack took place a few years ago in a country X, causing many injuries. The investigative judge issued arrest warrants against 12 suspected persons. Then Interpol issued red notices against them based on the said arrest warrants. But afterwards, it was revealed that the investigation were tainted since the judge paid bribe to the witnesses. So Interpol concluded that the red notices had not been issued in violation in violation of national and international standards. So it cancelled them. To avoid such failure by its members to observe fundamental human rights of the suspected persons, Interpol experienced that education creates a favorable environment. Indeed, it's very important to inform users to train them on the rules applicable, but it's also indispensable to educate them by explaining why these rules must be observed and by raising awareness on the risks linked to their non-observance. Finally, to make sure that fundamental rights and other Interpol's rules are observed, Interpol has established a multi-layered review or control system. It set up internal multi-perspective review mechanisms which apply at any stage of the processing of the information. But Interpol has also been the first international organization having established a totally independent review mechanism through the Commission for the Control of Interpol's Files, created in 1982. This independent organ has three missions: to provide advice to Interpol, to make spot checks on information process, and to process individuals' requests for access to Interpol's files, whether or not those requests challenge those files. To make sure that it offers an effective means of control and redress to the individuals concerned, the Commission can consult Interpol's national central bureaus. It has free access to Interpol's files, and it operates within the framework of a complaint procedure. Interpol experienced that the creation of such mechanisms that monitor the application of rules create trust and minimizes the risk for abusive use of information exchange. But I would like to present two final examples that illustrate the challenge that the international police cooperation has to face because of the contradictions between national legal regimes and or among international legal instruments. A UN Security Council resolution based on Chapter 7 of the UN Charter urges member states to share information on stolen and lost passports through the Interpol Stolen and Lost Travel Documents database. But what is supposed to do a police law enforcement entity or a requested country which does not apply death penalty if it knows of certain information available that could lead to the imposition of the death penalty in a particular case, one can imagine easily the consequence of a restriction imposed on account of the capital punishment by one country to another country to access to a list of identified persons traveling with identified stolen passports and planning a terrorist attack of unspecified civilian aircraft. The problem is that even on this issue, various conventions are not uniform. The EU legal advisor has recently given another example of the difficulty to determine which legal regime to apply. As you know, Interpol norms require proper observance of fundamental rights in any case. EU legislation imposes some limits to the police cooperation in case of violation of fundamental human rights. Under Chapter 7 of the UN Charter, the UN Security Council created an obligation for the UN members to freeze the assets of individuals suspected of participating to Al-Qaeda and Taliban activities. Based on the information provided to support an individual complaint, the EU Advocate General considered that the freezing of assets of the individuals suspected of terrorism, as required by the UN Security Council, had infringed his rights to property, to a fair hearing, and to an effective judicial review. As a result, he recommends the Court of Justice of the European Union to cancel financial sanctions requested by the UN Security Council. And whatever the issue of this case will be, it will influence substantially the legal framework of the international police cooperation. So to conclude, I would say that Interpol is constantly faced with the issue of balancing the needs of police cooperation and of protection of individuals' rights. And probably if Interpol were not to have a system to guarantee those rights, it would have closed a long time ago. So based on Interpol's experience, I would like to conclude by supporting the idea that proper observance of fundamental human rights in the course of international police cooperation is a condition sine qua non. Thank you for your attention.
Thank you, Florence. Thank you all. I would say unless one of the panelists has a pressing need to comment on what has been said, I open the floor to the audience. We have some 20 minutes more for questions. No pressing needs on the panel side. So the floor is to the audience. There's a question over there, the gentleman.
Eric Massey, working with Dr. Anton at North Carolina State. I have a question about data provenance. It seems really easy to regulate data collection because you either collect it or you don't. But once there's a time limit imposed on how long you can store data, or a number of hops imposed on how many people you can transfer it to, it gets really hard because the ideal scenario is you kind of have this Mission Impossible style piece of data that's going to self-destruct in 8 years, but that doesn't really happen in real computer systems. So my question is, how do you detect these problems in the first place, and what do you do about them? How do you address it or prosecute it from there?
Any volunteers who are answering that question? Thomas, you want?
Absolutely. You can design computer systems, for example, which flag a certain information, and they flag that that information is outdated after a certain number of months or days or years. And then you have to delete it. So you can't work with this, and you just have to push the button and delete it. And then to see if that's been done, you need external supervision to make sure that, for example, the police has deleted that information which should have been kept only until a certain time. Very basic answer. I don't know if it's satisfying to you, but you need to implement it. You need to make the humans work with the computers on this.
How does that work with the people you've shared that data with, or with the backup tapes that you've stored for that data, or the printed records that that data has been committed to and have been filed in a perhaps secure, perhaps not entirely secure environment? I mean, really, is data retention a theoretical construct that doesn't actually support real-world practices? I think that may be...
I think Peter Husting here. I think he's going to comment.
Everything happens step by step. We slow down the analysis that you need in every system, in every government operating in a regular fashion. You need access profiles, access control. You have audit trails, and there is a whole system of management of proper implementation of system. And then, of course, that translates into design of systems, etc., etc. So in the reality I'm dealing with, and I've dealt with before, we either find that a system is totally unacceptable because it is lacking all of this, or you have evidence, either by internal reporting or external reporting, that you go through the access, and then exactly all the examples just mentioned of supports for data have to comply with whatever the organization is legitimately doing. And this is exactly the point. It's about the architecture of the system, which should be in compliance with the rules. And so the principle is privacy by design. And it doesn't go from one big step from the law to the practice, but there is a big job for you guys to develop systems which are compliant by design, and then there are some loose ends and bits and pieces we have to face, but that's the basic thing. So there is a universe of mechanisms you need to get it done. It's very difficult to get this done in one step from a system where nothing of this exists, but I haven't seen them anywhere, to a very orderly way. So I would say from the library records, I'm just referring to your experience, up to the very complicated system, a bank, any bank, is able to reproduce what happens to its account. Even if it's then confronted with the fraudulent action of $7 billion, it's able within very short time to reproduce everything that happens. If you don't have that, well, sure, that's awful. It shouldn't exist. So that's the background in which we're talking. And rules have an impact then on these digital realities. So it's manageable. It can be done if you want it. But if you don't do it, bad news.
I wanted to join in and agree that in libraries, we usually structure systems, big integrated library systems, circulation records. If you return the book on time, and this should be powerfully motivating to this group, we will disconnect your personal record from the circulation, from what it is that you've been reading. If you're overdue, we're going to need to keep track of that for a little while until we can get the book back. So we do those things. Now the problem is, of course, there are backup tapes. We do privacy audits so that we make sure our systems are always compliant with these, that we do purge those backup tapes after a certain number of months. But the problem is the internet librarian, the world of social networking, the world of Amazon.com, if you can't get a library to protect the privacy of your reading habits, what's the world coming to? But that's what we're looking at. If library readers want to know, well, what is it that I've read so far? We have to keep track of that. That means that data not only is commercially safe, we're commerce, then it's discoverable as a security measure for national security by the government. So those are policy decisions for us if there's not a law about it.
The lady here in the front.
There's been a lot of discussion about
sorry, could you say who you are and which affiliation you perhaps
I'm
have?
Joanne David Perilla with the American Institute of CPAs, based here in Durham. There's been a lot of discussion about collection, use, retention, but no one's addressed the destruction. And I currently support the Privacy Task Force within the Institute, and part of our focus is to address the full framework from beginning to end, from the collection to the destruction, and where does privacy mesh into all those layers. I would think that any business that would seek outsourcing assistance or third-party vendors for the destruction of information should adhere to some privacy standards. And with that being said, you want to address that third-party business or your own business is destructing the data properly. So erasing data off a computer is not enough. Where's the scrubbing techniques or the destruction of the hard drive? My question is, I know that there are some organizations, nonprofit organizations, that are setting standards for very specific niches within this framework, but is there any one agency addressing it from A to Z?
Well, I think our DPAs have this vocation to address it from A to Z. I can tell only from my own personal experience where I had to notify a little data processing activity to Mr. Husting's people, and they did follow up after a half a year or 9 months and said, hey guys, you have promised to do this and that, what have you done now? And well, we did have to report, and so they do take this seriously, although one has to be realistic. I mean, there's thousands of operations going on, and resources are not always sufficient to follow up on each and every data processing taking place in the European Union. I don't know if colleagues want to say something more about this. Otherwise, I'm sure. Yes?
There's an ISO certification for accountants that, with respect to third-party vendors, that protects privacy. They don't have government enforcement behind it, but they do have a certification procedure so that an accounting firm can state all our third-party vendors are certified according to this ISO, I believe 14,000 is the number.
And there's also an ISO standard on records retention. I haven't read the whole thing yet. That's what I'm delving into, because we're trying to focus on developing a standard that businesses can adhere to, specifically accounting firms and how they address their client files and records so that they meet regulations and standards in the United States.
About Peter Swire, I have a question about information sharing, maybe especially for the European outside the U.S. So historically, there were two reasons that law enforcement didn't share data well. One was they had bad computers, and the other was that they didn't trust the other people and they wanted to get the arrest themselves. And this is the tradition, you know, we think for a lot of law enforcement, maybe other government agencies. But the computers are better, and the push for information sharing, at least in the United States, has been huge for the last 7 years with executive orders and things. And so my question really is, I've seen what the U.S. writing has been here, but can people point us to the best thinking in Europe about when information sharing is an appropriate response to the issues of the day, and how to do data protection and protect privacy at the same time that all this sharing is happening? So where are the visions, to the extent Europe has done this, about how to handle these two difficult tendencies?
Thomas, do you want to?
Yeah, I think it all again comes down to the matter of trust. And in the European Union, we're facing the same problems. And in order to be able to share information between police forces, we discovered that you need to have robust data protection rules in the first place. So within our institutional framework, that's what we're trying to do, to show and have for member states that there is a level of data protection where everybody can say, okay, I am sending this information to my colleagues in France, and because they will apply that level of data protection, I can trust them that they will deal with it in an appropriate manner. that needs to be there, because otherwise you won't get the trust. So maybe it's not good enough advice, but there is a legal framework in place, and that is the foundation for any information sharing. And then you add on purpose limitation, you add on need to know, specific provisions on how long you can get that information, and little by little you can share that information.
If I may add to that, I mean, we have a European police information agency called Europol, which is a bit similar to Interpol. It doesn't have enforcement powers, but it has precisely the aim of facilitating the exchange of information among the different national police forces. And they did have a slow start because of the reasons you mentioned. And I understand now this has gone much better. It takes time. It doesn't grow from one day to the other. It takes political will as well. And as Thomas said, it takes good rules, not only of data protection, but also of protection of the confidentiality of ongoing live case information, where obviously no police officer wants to have leaks on his case that endanger his investigation. So I think the Europol colleagues have tried to set up the gold standard of protection of this information to gain the trust of the European police forces, and I think it has worked so far within Europe. It is still an ongoing process. It is not, I understand not all member states are using Europol in the same fashion, but even those who had been very skeptical in the beginning, some of them have been won over and found out that this is actually quite useful, because unfortunately, well, the pressure of the problems is there. In Europe, perhaps it was earlier there than it was in the United States, where 9/11 has triggered a whole wave. But in Europe, we had this national terrorism, and we had the internal market much earlier in the 90s, where the borders were coming down, and where it was getting very difficult to limit law enforcement and to limit any enforcement actions at the national border. They had to be able to talk to their colleagues beyond the border. And this is how all these this arrangement has been put into place, first at the European level only, but now we are reaching out also to the US and trying to see what we can do beyond Europe. And I don't know if John wants perhaps to say something in addition to that.
Well, I may be going a little bit farther afield than what Frank was saying, but I've noticed one of the themes that's come up throughout the day, and I wanted to kind of pick up on something that Francesca, I think, more or less invited some discussion on, was the idea of oversight and having an independent data protection oversight authority. And I mean, I really think that's an interesting topic to talk about on the margins of the meeting, because independence is not necessarily a data protection principle. It's more a structure of government principle, and I approach it differently. I approach it as, is it effective oversight? And we have fundamentally different structures of government. In the U.S., there's the constitutional system with the three branches, and in the EU, you have the parliamentary system. And the two will never mirror each other. They will never look alike, no matter how much we wish it so. So I really think the question is, do you have an effective oversight system? And, you know, I would simply say that at least in the U.S., the model is networked and layered. You have all of these actors. It starts with a spectrum at one end where you've got the chief privacy officer in an agency, then you've got approvals that have to come from the Office of Management and Budget, where Peter Swire used to work. Also, the archives is involved in data retention issues. Then you have the Office of Inspector General. They oversee whether the agency is living up to following the law. And then, of course, you have the congressional branch, where you've got oversight there with the GAO and congressional subcommittees. And, of course, Congress can make or change the laws as they see fit. And then finally the courts. So there's this, it's not as neat a description as independent, but I really think at the end of the day, the analysis is it effective? And that's the question I'll just put out there, and I'll leave it at that. I'm not sure that independence is necessarily the silver bullet.
Can I make one further comment?
Yeah,
Just on the sharing point. It strikes me that, at least, it's very hard to generalize for Europe because each country has its own history. But it strikes me that the lack of sharing between intelligence agencies and police agencies is still considered to be a fundamental guarantee of rights. That the information that you're allowed to gather as an intelligence agency, you're allowed to gather it, and you're allowed to gather extensive information, as in the German case, where you can monitor all, this goes back to the G10 law, from the late 60s, and that's been revised a number of times. You can gather the actual content of phone conversations, something that we could never get in FISA, because you can get the content of phone conversations in national security cases without any kind of particularized suspicion, really. You only do it with using various search terms. But the basic guarantee that's there and that the court has enforced is that you can't transmit that information to the police unless you meet certain kinds, a certain threshold, and unless certain kinds of restrictions on what can be done with that information are placed. And so I think, at least in Germany, and it's very hard to generalize across Europe, there still is this idea that not sharing is actually one of the guarantees of liberty, of rights. And I think here there's been a lot of pressure to try to overcome what's basically bureaucratic resistance to sharing. It's not really principled resistance to sharing in the same way.
I would say, well, one more question, perhaps. Yeah, Giovanni.
I had the privilege to read during my incoming flight some of the contribution from Francesca Bin Yami about anti-terrorism, data mining, and law enforcement purposes. When we speak about this kind of processing of personal data, we traditionally have in mind a collection of data which are collected, which are recorded, which are preserved in police or judicial files. But we have now in Europe a new experience of interferences in the private sector. I would say some proportionate or disproportionate laws which oblige the private enterprises, in particular, I would say, telephone companies, to retain data to be used just in case. So it's a new phenomenon where millions, billions of data are recorded, and in practice just 200, 2,000 of them are really used. Which kind of experience you have in the US in the recent past? It's a question to you and to your American friends.
Well, I'm sure that many of the privacy compliance officers in the room would be able to also fill us in on this. But I think my impression is that there's, in the article that you read, I was dealing with the NSA's acquisition of phone records from AT&T, and the problem in the American case is that this data is retained for indefinite periods because you're allowed to do so. And there's no, and I hope that many privacy compliance officers will correct me on this, but in many cases, there's no categorical duty to erase your consumer records after a certain amount of time. And so so there, when the NSA went looking for data to put in its database, it had lots. And not by any design or anything, but just by virtue of how the private marketplace operates here and the lack of regulation as to the length of retention period that you have for this kind of telecommunications data. And so my impression is, but here again, I'm speaking from ignorance, and I know that a lot of people in the audience have a much better idea of this, is that companies routinely store customer transaction data for decades. And I hope people would correct me on that. But I think there's a lot of this transaction data out there that you're talking about.
And any reaction on this? Yes?
I just want to comment on this. David Hoffman from Intel. I think the issue, Professor Bignami is correct, but I think there is more of a spectrum of behavior there, and the issue is slightly more dynamic. I think first, in a difference from the approach that's been taken in Europe, I think we have had issues, and they've been highly publicized, with the government going and using its authority to obtain the data, or going and making specific requests without using its authority to get the data. I think what we potentially have even more is the government acting as a commercial actor to purchase data from folks and from vendors who will sell that data. And that's where I think it's more of a spectrum of behavior. That what I think we do have, not just here in the United States but internationally, is companies make their own determinations upon retention. I can only speak for the company that I work for, that we try to take the period of data retention down to the absolute minimum for which we need the data for the primary purpose for which we're collecting it. That's not so difficult for us because we're in the business of making microprocessors. We're not in the business of collecting personal data. So I do think it's a spectrum there, but somewhat different from Europe.
I'm afraid time is up. Thank you very much, everybody. We have 15 minutes break now, and we see you back here at 3:45 for panel 4 on global data flows and national privacy standards. Thank you.
Goodbye.